Christina Van Sickle is the Director of Professional Practice at the Ontario College of Social Workers and Social Service Workers. In this role, Christina aids in developing resources to support members in their competent and ethical practice, reaches out to stakeholders to promote how college membership contributes to a culture of excellence in the workplace, and supports the college's mandate of protecting the public. Christina has worked in the field of geriatrics, mental health, addiction services, and has wide-ranging leadership experience. Christina has developed and taught several courses, had a small private practice, and has served on a provincial board of directors. Christina, over to you.
Thank you so much, Andrea.
Welcome.
I appreciate that lovely welcome. So welcome everyone. I'm excited to be here and to be speaking with you all this evening. We've got over 300 people here today, so that's very exciting. And just wanted to let you know that yes, the presentation is being recorded, and so it will be available after the fact. I will be pausing throughout the presentation a couple times to ask for questions, and Andrea is going to be managing the chat function for me. So thank you for that, Andrea, I appreciate it. So there will be a few pauses throughout the presentation, but then there is a time for questions at the end as well. And of course, anything that we don't get to in the course of the conversation today, my contact details will be at the end of the presentation. You can also find them on the college website, and you're welcome to give either myself or my colleague Sue, who's the professional practice associate, an email afterwards with your question if we're not able to get to it today. I hope that kind of takes care of our housekeeping issues, and so we'll jump right in. So whenever we begin a presentation by the college, we always start with these 4 words because I think it really helps ground really why we're all here today. And also what clients can expect when they receive the services of a social worker or social service worker. So they can expect that they're receiving services from someone who is professional and who abides by a code of ethics and standards of practice. Of course, someone who's qualified and has done that advanced academic learning in order to get their knowledge and their experience about how to perform this essential role that we provide. And of course that you're accountable. Members of the college are accountable to their clients, they're accountable to their employers, of course to themselves and to the college as well. So it just kind of helps ground our presentation a little bit today. So we've already gone through our discussion, or pardon me, our introductions. We're also going to just touch basically and briefly on just the standards of practice, because again, conversations with the college when we're exploring private practice or any topic really, we want to ground them in the standards of practice and talk about professional judgment because it's such a big part of the job that we do. And I was asked to touch on a variety of different topics today. And so we've got a great selection of different topics to discuss. And we'll get through those just as best we can. And of course, like I said, we've got a time for questions at the end. So of course, as I said, the standards of practice, this is such a foundational document for members of the college. And what the standards of practice do is that they set out the minimum standards of professional and ethical practice and conduct. And I think that's really important to highlight because oftentimes when I'm talking to members or even sometimes employers or clients, individuals think that standards of practice outline best practices, and they do not. For a variety of different reasons. One, the college right now, we've got over 23,500 members. There's no way that we could create a best practice document that was going to meet the needs of all of those members, serving all of the different client groups that members of the college do, working in all the diverse practice settings, and even thinking about, practice between Niagara Falls and, Kenora look very different and everywhere in between. So best practices wouldn't make sense. That's one very good reason why they wouldn't. And so that what they lay out then is the minimum requirements for professional and ethical practice. They're universal for all members. And so it's for this reason that the standards of practice don't always speak to very specific practice issues or scenarios, and why we always need to be thinking about how to apply our professional judgment and what are other resources, such as perhaps our workplace policies and procedures or pertinent legislation that might apply to a specific situation. And as I mentioned, professional judgment, you will hear me say professional judgment a lot throughout the night. And it's really important because the work that we do, it's typically speaking not cut or dry. It's typically speaking quite nuanced. And it's instead of people using the term like it's not black or white, it's not. It's a beautiful rainbow and mosaic of different colors because of the individuals who we work with and the different places and settings where we work. And so this is why professional judgment is so key. And sometimes people kind of call it their professional spidey sense or their gut feeling, but it's honed over your knowledge and your skills and your experience. And consultation is such a big part of forming that professional judgment and critically analyzing the critical aspects of potential outcomes. Mondays and Monday evening, having difficulty getting my tongue around certain words. And so, this is why it's such an important part to reflect upon professional judgment because of the work that we do. So the first topic to talk about then is psychotherapy, which of course was one of the topics that was brought forward as wanting to have further discussion and understandably so considering the topic of this evening. So we know that members of the college, they can perform the Controlled Act of Psychotherapy and they can use the title psychotherapist as well. But if you're to go on the college website under the psychotherapy page, which if you do want to do some exploration on the college website, which I will also refer to a fair amount tonight as well, underneath the professional practice tab, which you will see on the main screen of the OCSWSSW website, there's a pop-down menu and psychotherapy has its own dedicated webpage. And what it says is that members may perform psychotherapy and use the title psychotherapist in compliance with the Social Work and Social Service Work Act, its regulation and bylaws. And so, what does that mean? That's interesting. And so we're going to talk about it on this slide and the next slide. And so what it means in reference to using the title psychotherapist is that on that webpage that I just highlighted, we have examples of how members of our college can use the title psychotherapist. And there's several different examples, but essentially you have to indicate that you are a member of this college as well, that you are a social worker psychotherapist. What we can't do is use the title registered psychotherapist or the designation RP, unless some of the individuals who are on the chat tonight, you may also be members of CRPO. We do have some individuals who are dual members of both colleges. And by all means, if you are a member of CRPO, then you can use those titles, but they are designed and set aside for individuals who are members of the College of Registered Psychotherapists of Ontario, registered psychotherapist, or the designation RP. But what our members can call themselves is psychotherapist, but it has to be social worker, psychotherapist, or Ontario College of Social Workers and Social Service Workers psychotherapist, or registered social worker psychotherapist. Those are the three different ways that it's laid out in the Social Work and Social Service Work Act that we're entitled to use the title psychotherapist. What this also means, this compliance with the Social Work and Social Service Work Act about performing the Controlled Act of Psychotherapy, is essentially the Act lays out that the college has to create the standards of practice, and members need to practice according to the standards of practice. And when we're talking about practicing with psychotherapy, essentially it means that you're wanting to be ensuring that you are competent to perform the Controlled Act of Psychotherapy. And in the standards of practice, we talk in Principle 2, which is competence and integrity, and its interpretation 2.11, that members are responsible for being aware of the extent and parameters of their competence and professional scope of practice and limit their practice accordingly. Okay, so what does this mean exactly? So we need to determine whether or not we're competent to be able to perform psychotherapy and the Controlled Act of Psychotherapy. And again, if you go to the psychotherapy page on the college website, we talk about the two different definitions between psychotherapy and the Controlled Act. They are different, they are similar. You could easily move between doing one and the other. And so we talk about when we conceptualizing psychotherapy as the Controlled Act, because certainly we've developed specific guidelines to help individuals consider if they're competent to perform the controlled act. And you may be providing psychotherapeutic services, and due to the nature of the client situation or the conversation that you're having, easily move into the controlled act. So it's just, as a conceptual piece, easier to think of when we're talking about psychotherapy as the controlled act of psychotherapy. And so when we look at this interpretation, we talk about, being extent, or being aware of the extent and parameters of your competence. So that's really doing a self-assessment and being really critically reflexive about the skills and knowledge and experience that you bring to performing the controlled act of psychotherapy. And we're going to talk about that a little bit more in the following slides as well. But also your professional scope of practice. And in this context, when we're talking about professional scope, it refers to your usual area of practice. So for instance, off the top, Andrea had mentioned that I had a private practice before coming to work at the college. And, I'm skilled in using CBT and mindfulness techniques, motivational interviewing. I am not skilled in doing EMDR or working with individuals who have complex trauma. It's just not an area where I have done that level of training or skill or knowledge development. And so what this means in my context, that when I was doing my private practice, if I was approached by a client who wanted either EMDR or had complex trauma, that I likely wouldn't be the best person for them. And so it's about me understanding what my limitations are, and either, typically speaking, referring that person on to someone who is able to meet those needs. There is provisions in the standards of practice about how to work with someone for getting ongoing supervision or ongoing training in order to build up that level of competence. But really, in this context, what we're talking about when we're considering private practice, when we're considering psychotherapy, it's first of all, looking at, do I have the competence to perform the controlled act, which we're going to review in a second, and B, do I have the requisite knowledge and expertise in the area of practice that is going to meet the client's needs? And if you don't, that's okay. We can't, know all things and be all things to everyone. And then it's about referring them on to the appropriate individual. Scope of practice also can refer to as well at the beginning of the Code of Ethics and Standards of Practice document, that there is a scope of practice for social workers. And it talks about the provision of assessment, diagnostic, treatment, and evaluation services. And so certainly it's a very broad understanding about scope of practice. And certainly the provision of psychotherapy falls within that. But we do talk, as I've mentioned, about limiting the services that you provide to clients based on your usual area of practice or your usual professional scope of practice. So getting back to what I was speaking about looking at people's different competencies and different perhaps criteria or considerations that people want to explore when considering if they're prepared to perform the controlled act. And we've created guidelines to help members with this, and that they, again, are available on the college website. And they're helping members to identify factors that they should consider in order to determine if they're competent to perform the controlled act. And it's interesting because I've had lots of different conversations with individuals and organizations about this checklist of considerations that you'll find at the back of these practice guidelines. And people want them to be very prescriptive, and they want them to be very neat and tick boxy. And that you can say, yes, I've done this, 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 and this, therefore good, I'm done, I'm competent. And they've intentionally not been created that way because people are complex and nuanced. And it could be that you can tick all of those boxes very neatly, but you're still not competent to perform the controlled act of psychotherapy for a variety of different reasons. Or perhaps you're still working towards getting some of those competencies, but with supervision and support and with the feedback of others, that maybe you are competent. And so these are things that you're working together because each person is different. And so again, this is an area where you have to apply some of your professional judgment. And what we also say as well is also consult with your mentors and supervisors and managers and colleagues to really help you critically reflect and analyze if you do have the requisite competence to perform the controlled act. And so what it talks about in the practice guidelines is that, so in addition to your degree in social work, because just simply having a degree isn't sufficient training enough to do this work, that you want to have a further degree, diploma, or certificate from a program focusing on the Controlled Act. That you want to have post-degree or diploma experience of 2,000 to 3,000 hours or 2 to 3 years of supervised experience performing the Controlled Act. That when you were doing your coursework, either in your degree or post-degree, that your coursework and your practica had a clinical focus. Of course, you've engaged in a period of extensive clinical supervision. You obtain regular supervision with respect to practicing the Controlled Act. That your goals in the CCP or continuing competence program are heavily weighted towards performing the Controlled Act. And of course, that you're aware of confidentiality, boundary issues, and of course, especially in the work that we're providing right now, including those boundary issues that can be raised by the use of technology that we are going to touch on moving forward. And so how those different issues could impact your practice. And so that's kind of how members can go about reviewing the documents, reviewing their practice, consulting with others, and really applying that reflexive judgment to determine, do they have the requisite knowledge to perform the Controlled Act? And what are the ongoing learning activities and learning goals that they're going to create in order to either gain that competence, or as professionals, we also need to maintain that competence on a go-forward basis as well. So I want to take a pause there for a second, because that was a lot of information, I realize, and I can see that there are some questions coming in. And so Andrew, I'm wondering if maybe we've got a chance just to take 2 questions right now before we move on to the next topic.
Got to unmute myself. Thank you. Okay, we do have a few questions. There's about 3 questions from one individual in regards to the client living outside of Ontario. And the second question is in regards to the counselor being outside of Ontario.
Yes. So we are going to touch on that more, but I'm happy to touch on it now. So it's very interesting because we do actually have a newly minted webpage as well that talks about cross-jurisdictional practice. And so as a member of the Ontario College of Social Workers and Social Service Workers, you are registered to practice with clients who are in Ontario. And so if you're considering practicing with a client who is not in Ontario, then you'd need to contact the regulatory body where that client is located to ask that regulatory body what are the regulatory requirements in their jurisdiction. The other interesting flip side to that is that so long as the client is in Ontario, the social worker who's registered in Ontario could be anywhere. And so that's the flip side of that as well. So we certainly have heard from individuals who are moving abroad, but are still practicing with clients who are in Ontario. And as long as those members maintain their registration with the Ontario College, then that's absolutely above board.
Second, is that 2 or is that 1?
No, that's 1. That's fine.
Okay. The second one is, if we decide to maintain only virtual practice even after the pandemic, but don't want to disclose our home address to the clients and their insurance companies for safety and privacy, for instance, on their session receipts, is it sufficient to use a post office box?
So, I mean, it's a very good question. And I mean, I think that you probably have to speak to the individual insurance companies, because it's not a requirement of the college that you have your address on your invoice, period. That's not information that we require to be there. And so I've had this question before, and that's what I'm able to say from the college perspective. And it may be worthwhile, if there are insurance companies who are requiring that information, to have a sidebar conversation with them about what they need in order to process the invoice. Because again, it's not a requirement of the college for you to have your address on an invoice. Okay.
Thank you.
That'll be our 2 for now, I think.
Yeah, that's fair.
Perfect. So then I was asked, which was really interesting and allowed me to kind of think and put my thinking cap on a little bit, about just in respect to private practice, what are some of the ethical considerations? And there are many. And we do have a lot of resources on the website as well. There is a private practice webinar on the website about preparing for private practice. There are different readings and practice notes that we have there as well. But I thought that I'd kind of do a roundup, if you will, of some of the most kind of highly discussed or considerations when we're talking about private practice. And number one is that we don't view it as an entry to practice competency. And of course, you know, individuals all come to private practice from different places in their lives, but just merely having a social work degree or social work education doesn't fully prepare you for private practice. That typically speaking, you'd be thinking you'd want to have at least a few years of practice under your belt, some supervision under your belt before you decided to embark on private practice, because it is a very specialized skill. And the other big piece about it is it's very isolating. That oftentimes individuals who are working in private practice, they might be working by themselves. They might be working, even if you are part of kind of a collective or a group, that you might not be meeting together all at the same time. So it can be very isolating, which is again, some of the reason why you need to have further experience and knowledge and judgment around how to work independently. So that's why we say it's not an entry to practice competency. It's also important to have access to regular supervision. And, you know, it's interesting that I've had conversations with individuals in the past of like, well, you know, I'm a very experienced person and, you know, I don't require the same access to supervision as perhaps someone less experienced would. And you know, there's truth to that for sure, that as your practice progresses and your experience progresses, that you won't have the same perhaps supervision needs as you do when you're first starting out. But regardless, that should always be access to regular supervision, because you are a human being. You are going to come up against issues with which you don't have familiarity, or perhaps are triggering for you or triggering for the client, where perhaps you're going to benefit from additional skills, knowledge, or support. So I think access to regular supervision is something that we always say that when you are starting out on private practice, you know, just as important as figuring out, you know, your website, your business cards, is figuring out who's going to be your supervisor as well, and to get that kind of laid down. And as we also call it as well, that it's also the cost of doing business, right? That if you're going to embark on private practice, and this is an investment in your own knowledge and growth, is to have access to that supervision. This may seem obvious, and it certainly does speak to having the access to regular supervision, that we need to be aware of our own values, attitudes, and needs. And, you know, this is something just kind of in general practice to be aware of. But certainly because of the isolating nature of private practice, and because, you know, we are often the first resource that we have to draw upon when working with clients, that we do have to be very aware of our own values, attitudes, and needs with working with clients, and also thinking as well, you know, we often get conversations with members, you know, thinking about potential conflicts of interest when taking on clients and what that might look like. And, you know, it can be challenging at times to sort of suss out, you know, should I take on this client? I've known them from another organization, or, you know, they're being referred to me as a friend of a friend, or what have you. And especially when you're starting out your practice, you're really excited to get clients, but there also needs to be that built-in ability to sit down and critically reflect if you are the best person to be taking them on, or if it's just kind of your excitement and your desire to build your client base that's maybe fueling this. And so that can be something to really consider as well. And, you know, a question that's always pertinent to ask, especially in private practice and taking on new clients, is, am I the best person to be doing this, right? Or is there somebody else who's better skilled or better positioned to do this? And so that's part of the an ethical consideration when taking on new clients, and even when doing the actual work with the client themselves. Of course, informed consent is a big part of the work that we have to do with clients. And, you know, that really focuses on, and we talk about this in Principle 3 of the Standards of Practice, and that you really need to ensure that college members are providing their clients with accurate and complete information regarding the extent, nature, and limitations of any services available to them. And you're also informing your clients of the foreseeable risks as well as rights, opportunities, and obligations associated with professional services. Because I think that's a very valid thing that we have to think about as well, that you have rights, you have opportunities as a client, but there are also some risks as well that this could bring up a lot of painful memories. This could bring up some painful experiences. This might be challenging, and so really providing clients with all of the information that they require to make an informed decision about whether or not they want to proceed with receiving your services is very important. Another ethical consideration is, of course, keeping your documentation for 7 years, and that's at a minimum. So it's 7 years and it could be more. So times when it's more is that if you're working with children or youth, it's 7 years from the time that they turn 18. So if you're working with a 15-year-old, for example, and you discharge them, then it'd be keeping those records for 10 years, right? So it's until they turn 18 is those additional 3 years, then 7 years on top of that. Other circumstances where people choose to keep their documentation longer is if they are working with individuals where there might be some legal issues coming up, or there's a high legality, litigious nature to the case. And other times that I've also heard about it as well is when individuals have had high experiences of abuse as well, that may be a reason for keeping it on. But of course, thinking about that critically and even investigating, perhaps even through your professional liability insurance, which we are going to talk a little bit more later, obtaining a legal consult to determine if there is additional need to keep certain files longer than others, but it's at a minimum 7 years. And so when we're talking about private practice, you have to think just even spatially, even practically, do you have the ability to keep someone's documentation in all of these files, and how are you going to keep them for that amount of time? And when we are talking about the record, interestingly, when we're talking about accessing the record, if you are working with a couple or a family, one of the ethical considerations that you may have to contend with is if one member of that couple, let's just say for ease of my example, wants to have access to the record, and the other member of that couple dynamic doesn't. So then it's about only providing information from the record about the one client who's provided consent. And so it's not a matter of that if you're just working with a single client and they request a copy of their record, you can provide them with that record. It's their record, that's fine. If it's a couple and one person consents and one person doesn't, it's about figuring out how you're going to provide that individual who wants access to the record. And either it's through redaction, either it's through summary, but how are you going to provide that individual who wants to have access to their record when it's a joint record? How are you going to facilitate that? And if you're working with couples or with families, then that's a really good conversation to have at the outset about what that would look like in the event that one of them wants to have access to the record and the other individual isn't consenting for their information from the record to be disclosed. So that's important information to consider that we often get a fair amount of conversations with members about. A contingency plan for your documentation. So this is another interesting one where the standards of practice speak to this as well. And members who are in private practice, as we know, you need to keep your documentation for 7 years. We just talked about that. But if there was an event where you were all of a sudden not in private practice anymore, perhaps you won the lottery and that's it, I'm done, I'm not doing it anymore. Perhaps, you've just retired and you're not interested anymore. And unfortunately, we've even had to talk to individuals in the circumstance where unexpectedly the social worker died and they were all of a sudden no longer private practitioner and they were no longer with us. And so how are your clients going to access their records if they want them? And so this can be an area of private practice that, while sometimes a little bit uncomfortable to discuss, it's very practical and something that thought needs to be given to. And we've certainly spoken to members who in their will, they do have a professional clause in their will that in the event of their death, this is who's going to take over their files. And this individual knows how to access their files and their documentation, and that clients will be notified of how to find their onward files through X, Y, and Z process. And so certainly that is something that through your private practice, that you do need to consider that if just for whatever reason that you were no longer available to provide your clients with their records, if you stopped practicing and 6 years later they came asking for them, what mechanism is going to be in place in order for those clients to get access to their records? So something that needs to be considered. I'm just going to pause here to have a little sip of water. So of course, a really big other ethical consideration is the limits of confidentiality. And we know, as members of the college, oftentimes we kind of, I call it almost like your boilerplate kind of ability to sort of rattle off, what are the limits of confidentiality when we're talking with the client. All the information that we talk about will be kept confidential, but just so that you're aware, if you inform me that there is a reasonable doubt or reason to believe that a child is in need of protection, or that, you've had a sexual relationship with another social worker, or that, you're harm to yourself or others, these are all reasons why I may need to disclose client information without consent. So being aware of what those are for you, because there are some standard ones that apply to all of us, which are the ones that I just kind of rattled off. But certainly, with your supervisor, if you're sharing client information with your supervisor, then clients need to be aware of that as well. So to let them know that for the practice or for assisting you in their client care, that you do sometimes share information with a supervisor. If there is an administrator at your office who may have some details of your client information, letting them know about that. If you do kind of work part of a collective, that you may share things at team rounds or a multidisciplinary team, those aspects, clients need to be informed of that. And within reason, they also need to be given the ability to lockbox some of their information. So when I say within reason, you're not allowed to lockbox if they tell you that there's reasonable grounds to believe that a child's in need of protection. You can't shut that information down. That information has to be reported. Do not pass go, do not collect $200 kind of thing. But if you are working as part of, say, an interprofessional team, for instance, and perhaps, Andrea and I were on the same team, and Andrea is working with a client, and they say, you know what, I understand that you sometimes share information with your teammates for the purpose of client care, but do not share anything about Christina with me. I do not like her. I don't get her. Just don't talk to me. Don't talk to her about me at all. Then Andrew would say, okay, right, that's fine. I can respect that. And that's called putting a lockbox on your information. And so those are some of the limits of confidentiality that we have to explain to clients as well. And that can certainly be some ethical considerations that we do have to provide when meeting with clients. Transparent billing practices and fee schedules. So we know that, and as we talk about this in the standards of practice, it's principle 6, we cannot charge or accept any fee that's not fully disclosed. And we also, and this speaks to informed consent as well, that we have to explain in advance or at the commencement of a service the basis of all charges and give a reasonable estimate of projected fees, pointing out uncertainties, so that clients can make informed decisions about whether or not they want to move forward with receiving our services. And we have gotten calls from clients in professional practice department who sometimes dispute the bills at the conclusion of services because they state that they weren't fully informed of the basis of all charges, the basis of all charges at the beginning. So that's why it's also advisable to have this in writing as well, for the agreement. And, of course, members are welcome to provide a sliding scale if they wish. Members are allowed to provide services pro bono if they wish. All of these things are permitted, but again, it is oftentimes advisable to have this information in writing with members, with clients as well, so that everybody's on the same page. And then another one which we sometimes consult with members about and employers about is we can't accept or give referral fees. And how it's written specifically in the standards of practice is that college members do not accept or give commissions, rebates, fees, other benefits, or anything of value for receiving or making a referral of a client to or from another person. And this is put in place to essentially protect clients from conflict of interest. So from individuals, referring back and forth to each other when perhaps it's not necessarily in the best interest of the client, and making any other kind of deals with being able to grow your client list in a way that may not be client-centered. And so that's why that piece is in. And we have gotten a lot of questions about that in the past as well, because I know in a lot of other professions, receiving referral fees is a very common practice. So it can be surprising, especially if social workers are working with individuals in their practice who are a different profession, and where that might be a very common practice in another profession, it's not something that's considered an ethical practice in social work and social service work. Similarly, another ethical consideration is when you're advertising your services, that it needs to be factual. So you can't pretend to do something that you can't. And you also can't say, I'm Christina, I'm the best, I have this great service, don't go see Andrea. Andrea's services are no good, right? Come see me. So that's something that you're not allowed to do. You're getting picked on a little bit, Andrea. You're not, it's okay. I appreciate it. Thank you. So you're not allowed to say that. It's not fair, right? That, I can't downplay somebody else's services and say that mine are better. And I also can't boast to say that I have credentials and experience and knowledge that I do not. Another big one that we get a lot of questions about is around client testimonials and endorsements. And it's understandable we get questions on this one a lot, because we do live in such a world of, reviews, right? And Google reviews and Yelp reviews and Amazon reviews and reviews and everything, right? And oftentimes people don't want to purchase any services until they've been able to see the reviews, and that's understandable. But again, this is an ethical consideration about why it's prohibited in order to have client testimonials or endorsements. And it's because of the power imbalance between social workers and their clients, because a client may feel coerced to have to give a testimonial or endorsement. They might feel that in order to receive continued quality of care, that this is something that they need to do. And then I've also been approached by members as well who've said, but I didn't ask for it, the client's offering it. And fair enough, I'm losing my earpod as I'm talking to you. Fair enough, that may happen. However, perhaps that client, that's part of their transference, and that they want to please you and that they want to gift you something. And so that's one of the reasons as well why we say no client testimonials or endorsements. And then, of course, the last ethical consideration I've put down, no boundary violations, which is obviously a huge sweeping statement. And, boundary violations can, go from having client testimonials and endorsements all the way up into, having a sexual relationship with a client. And so, it's a huge conversation just in itself. And unfortunately, if you're able to look at the discipline pages on the college website or in the prospective newsletter, that you do see that some of our members do have sex with their clients. So don't do that. Don't do that. But, we do have to be very mindful about boundaries. And especially when we are, so many of us working now in this virtual online world, boundaries seem a little bit more different and a little bit more diffuse. And we're going to talk about that a little bit more moving on as well. And so that was kind of a huge, I was asked to talk about ethical considerations, and there's many. And so I tried to do kind of an overview of what that might look like. But I'm going to pause here again now as well, Andrea, and just to see, I know that there's some more questions coming in the chat, so we'll pause here for a couple questions just to see if there's anything that I missed there or people want further clarification with.
There's quite a bit of questions. Mm-hmm. Let me start with one that came at 6:57. It says, when you say a degree, do you mean a specific degree, or can it be around a specific modality of therapy, i.e., if I did training and supervision on IPT, trauma therapy, attachment therapy, does that fit?
It's a good question. And I think this is where we talk about that checklist not being so prescriptive, right? And so I'm not here to tell you if that's going to be the right one or the wrong one. It sounds really good to me. It sounds like you would have, if you were called into question in order to demonstrate your competence, that you would have a sound body of evidence there to say, yes, see, I have completed this certificate, I've completed this course, this is how I have earned this competence to do this specific modality. And so, I mean, I think that that would certainly be something that you would definitely count as, and when you look at that checklist of considerations, it's almost like building a portfolio of experience, knowledge, and judgment. And that would certainly be part of that portfolio. That I would say that, again, if you were ever called into question to say, are you competent to do this? Prove it. You can say, well, yeah, here's my certificate of completion of this course that I've taken and all of these other things. Now, I can't say that taking that specific course by itself is going to say for sure that you're competent, because there are other factors on that list as well. But I think that would definitely be part of creating that portfolio to show and be able to demonstrate evidence of your competence to perform the Controlled Act.
There's a redress to the question about the address. And two people responded and said, does that apply to the client being on vacation, but still wanting to have a session? Not a client who lives abroad, but just on vacation.
It does.
And the second person, I guess, added on and said, if they can work with clients who have permanent address in Ontario, but are out of the province temporarily.
The way that it has been viewed, and this is across Canada, so all of the Canadian social work regulators have gotten together and chatted about this. And they do that on a regular basis. The Canadian regulators get together and chat. And yeah, it's even if it's on a temporary basis, we have a lot of questions as well from individuals. Like, let's say if it's a student who's coming to school in Ontario, but they're from BC, for example. Then yeah, I mean, if they're from BC, but in Ontario, the expectation would be that you'd be registered in Ontario. Same thing, that if they were a student, they're an Ontario resident, but going to school at UBC, then yes, you'd need to contact the regulatory body in BC to find out if you can continue working with them. To this point, I will also add that often, I think all of the different regulatory bodies have a special consideration for exactly these cases. So for example, in Ontario, let's just say somebody from BC wanted to exclusively practice in Ontario virtually, then they could become a member of our college for $50 a year. And the same thing is within BC and Alberta, they have these different types of registration for those colleges for individuals from other provinces who are just going to be practicing exclusively electronically. So for example, BC used to, I don't know if it still does, but even had a provisional license to work in BC that for a year was free. And some other provinces have something very similar. So across Canada, there is this agreement between the provinces that you can become registered with their college, typically for a reduced fee, if you are going to be providing services to a client in their jurisdiction.
Okay.
Okay.
Can I sneak another one in?
Yeah, go for it. Go for it.
This one says, can you clarify supervision for the 2 to 3 year experience performing the Controlled Act? Could peer supervision in a group social work practice count?
Yeah, I mean, I suppose it probably could. And again, this is why, I will say it again, that it's not, the checklist of considerations isn't meant to be overly prescriptive, because I can't say for sure. I don't know your peer supervision group, or even if you have one, this could be hypothetical. But I guess as well, not all peer supervision groups, and some people don't even go with the term peer supervision. Some people say peer consultation. I mean, not all of them are equal. I mean, not all of them, sometimes it can be very ad hoc, they can be very formal. It can depend who are the professionals there. So I think that it potentially could. But I think that you should certainly sort of look at the structure of that peer consultation group. Is it formal? Is it structured? Who are the mix of professionals who are part of that peer consultation group? What is the levels of experience that you have? Is there access for consultation on an ad hoc basis in between your structured groups? Do you meet monthly, weekly, biannually? What does that look like, right? And so not all peer consultation groups are created equally. And so certainly, again, a good litmus test when you're considering, like, would this count? Would it not count? If you were ever called into question by a client, by an employer, by the college, about how are you demonstrating that you're competent to perform the controlled act of psychotherapy, what would your evidence be? Again, it's building that portfolio. And you say, well, I have received, I went to this peer consultation supervision group, and we met, you know, bi-weekly or monthly, and it was this mix of professionals. This was our agreed plan for the cases that we were going to bring. These were our terms of reference. You know, or is it, well, it's just kind of a chat group that, you know, I met with, you know, every 6 weeks or so, and sometimes we show up, sometimes we wouldn't. Those are two very different things. And so you really have to apply your professional judgment to determine which one of those would then be creating that body of evidence that you need to be able to demonstrate that you're capable of performing the controlled act.
Thank you.
Thank you. The next one's really quick, so we will we'll be able to do a couple more questions shortly. So I was asked as well to focus on documentation, because clearly I'm sorry, I've got a squeaky chair. I'm sorry if that's a feedback for you. Because documentation, obviously a very important part of private practice, and, you know, obviously important part of being a member of the college as well. And the question was paper versus electronic. And so what's the value or the challenge of each of them? The college doesn't determine or dictate if you're going to document paper or electronic. That is your choice about what you want to do. And I think there's a lot of factors that need to be taken into consideration when you are determining about what you want to do. Sometimes paper is just more comfortable for people. Sometimes electronic's more comfortable for people. Storage is certainly one aspect that if you are, let's say, using paper storage, you know, you've got to be able to put all those files somewhere, right? So do you have space in your home? Do you have a filing cabinet where you can put those things? Can that filing cabinet be locked? Is it somewhere where people with no reason to be looking at the files would be placed? Can you have the security that you need for that storage? Similarly, when we're looking at doing electronic documentation, you know, where are you storing those electronic files? Are they safeguarded? Are they secure? You know, is it password protected? Is it encrypted? Is it somewhere that no one who has any reason not to be looking at your files, you know, they wouldn't be able to find them easily? If you're using a database, a paid service, you know, where are those files stored? Are they stored in Canada? Are they stored elsewhere? Is the jurisdiction where the files are stored, or is it in compliance with Canadian or Ontario legislation? So there's certainly different aspects that you need to consider when determining if you're going to use an electronic database system or an electronic mode of documentation. Competency is another big one as well, that if you are choosing to document electronically, are you familiar with the system? Do you know what to do if you need to make an amendment, if you need to show a correction, if you need to produce files for a client, if you need to produce files that are redacted or create a summary because you are working with a couple and only one member of that couple has provided consent for you to access the file. So there's a big competency piece that can be there when you're thinking about electronic as well, which probably wouldn't be there in the same way for paper files, I wouldn't think, but still you have to be competent in documentation practices for paper files as well. And of course, you know, as I've already hinted at with the storage piece as well, security is a really big piece of this. And, you know, if you are using an electronic system, an electronic database, then clients would need to be informed as well as part of the limits of confidentiality, if there were any confidentiality potential issues with your documentation database. And so they need to be aware of that and fully informed so that they can make an informed decision about whether or not they're comfortable proceeding with your services if that's how you document as well. So Andrea, that was that one specific topic, and now you were the one who brought that topic to me. So I don't know if for that specific topic there was any further follow-up that was needed, and if there wasn't, then we can take another couple more questions as well.
someone has worked in healthcare, geriatric psychiatry for 20 years plus, but due to systemic issues, there has been no direct supervision. How does this impact future private practice with this population with respect to the Controlled Act of Psychotherapy?
That's a good question. That's tough. I have worked in geriatric mental health, and I can appreciate how challenging that must be to not have that supervision. So I guess a few things that you need to consider, first of all. That there's been no direct supervision, but has there been opportunity for either social workers and their allied professions to get together and have those peer situations where they're able to consult with each other? If there isn't, could you create one? Is there any other professional at your place of work whom you are able to consult with? Because supervision doesn't have to be from a social worker either. Social workers are able to receive supervision from other professionals, and they're also able to supervise other professionals as well. So is there any other profession, because there are 6 regulatory colleges whose members have access to the Controlled Act. So is there a nurse or a doctor or an OT, or a psychologist who perhaps, could also help provide some of that supervision as well, that maybe that's something that you could connect with? Is there any potential for your organization to bring in an external counselor or, supervisor? Actually, I've heard of that more often than you might think from some organizations as well, where they don't have the supervision capacity and they have brought in somebody, they've contracted with an external supervisor and brought them in to do group supervision with the social workers and RPs. Or is this just something that perhaps, you want to go out and contract with someone to be an external supervisor as well? So there are different options out there. And I think probably first things first is really trying to marshal the resources that you may have available to you at your own place of work. For who could maybe, even though you don't have anybody on your own specific unit, is there anybody in the organization who you could approach or who you could connect with, or a group that you could start to start doing that peer consultation piece? And so those are maybe some other options that you could explore as well. Okay.
So this statement, not exactly a question, I think I really do need to bring it up. It was shared with everyone, so it might as well be shared with you.
Sure.
It says, I consulted with a lawyer who informed me that as long as I inform the prospective client that I'm registered in Ontario, the client, who may reside in another province or state, may still use my service. I have them sign a document stating that if they choose to sue me, I've never been sued, in brackets. They agree to do so in a Canadian, if not only Ontario court. This means my professional liability will protect me. Prior to COVID, when I was seeing few clients virtually, I did speak to the regulatory body in the other jurisdiction, but the legal advice I received now indicates the client is seeing me in Ontario.
Well, that is a tricky nugget of information there. And I mean, I applaud you for getting legal consult and to speaking to the regulatory body in the other jurisdiction. I think that's fantastic. And I mean, it's tricky to say that, I mean, that isn't what this college says. But that being said, if you have spoken to the regulatory body in the other jurisdiction and they've said, have at it, go for it. I mean, that's not this college's jurisdiction to be able to say what you can do in another area, right? I'm curious about that they're not able to sue you or just be able to sue you in Ontario jurisdiction. I have never heard of that before. And so certainly a lawyer is much better able to answer that question than I am, but that is news to me. So thank you for sharing that information.
Another question, straightforward. How do you go about finding a supervisor?
Oh, good question. There's a variety of different ways. One of them, if you go to findasocialworker.ca, you can search for social workers based on their area of specialization. And you can put that into the search field, and you can search for somebody who does supervision that way, and also in your geographic region. The OASW, Ontario Association of Social Workers, can be a great resource in this way as well, that they may either have a list of people who are able to provide those services, or they do also have a private practice email group where if you are a member of the OASW, you can ask to become part of this. It's called an email listserv. And that would be a question that you could put forward, and it's all social worker, private practitioners part of this email group, and that they'd be able to direct to that as well. And just word of mouth, ask around, right? Ask around. Yep.
Another straightforward one is, do you need to have an RSW as your supervisor?
No, you don't. If you are receiving supervision for the Controlled Act of Psychotherapy, you need to be receiving supervision from a professional who's part of one of the 6 regulatory bodies who has access to the Controlled Act. So what that means is that social workers, social service workers, our college, nurses, doctors, OTs, psychologists, and psychotherapists. Those are the 6 regulatory bodies whose members can perform psychotherapy. So you need to be supervised by a member of one of those 6 regulatory bodies. As a side note though, if you are being supervised by a psychologist, supervision in their standards of practice means something different than it does in ours. And so if you're approaching a psychologist for supervision, then what that means to them is that they are responsible for your clients, and that they're responsible for the billing and the documentation, because they are supervising your practice until you're able to independently work on your own. And so if that's not, and some social workers enter into that agreement with a psychologist, and that's their choice to do so. But if you want to have supervision from a psychologist in the same way that we might understand it, then you might ask for consultation or mentorship, pardon me, instead. So just a little side note there.
You sort of touched on this one. The question is there a difference between supervision and consultation? If I receive formal consultation from an experienced therapist, does that count as getting supervision?
Yeah, I mean, it is interesting, and there are and there have been really interesting conversations about consultation versus supervision. The one very acute difference between the two of them is that in consultation, names are anonymous, and that in supervision, then you are permitted to share confidential client information. And also the other way that it can be really clearly delineated is that if you are a supervisor and you have a supervisee, then that is a clinical relationship. And so you have the same debt of professional responsibility to your supervisee as you would to a client. And so you'd be expected to document, and you're accountable for the supervision services that you provide to that person. So there is that piece to it. Now, consultation may very well be structured. There may be some documentation that occurs, but we definitely not see the sharing of client information. Like, it'd be a sharing of anonymous information, not identifying information. And there'd be that, it wouldn't necessarily be the understanding that there'd be that clinical relationship between the two, supervisee and supervisor. So that's one of the ways that you can delineate.
Okay.
Okay.
Next question. If I was leaving an agency and my clients express that they want to continue working with me even after I leave the agency, would I accept or decline them as clients in my private practice?
That's a tricky one. That one's very layered, and it depends, right? It depends. So you may need to first review your agency's policy, because some agencies have non-compete policies where you cannot take clients from your previous agency into your private practice. And that's where you got to start. That being said, you may be able to accept referrals from your employer or former place of work to be your client. And so that's something to look into. And so that would be something to look at. Then the other piece of it as well, and it's a big discussion, because is it the best client outcome for them to continue to see you? Is it better for them to perhaps explore someone else's techniques or modalities? Could it potentially be perceived that you were being influenced by your own financial or professional interest in bringing this person into your private practice? And that would be called a conflict of interest. And so the really interesting thing about conflict of interest is it doesn't have to be actual, it could just be perceived. So is there the potential that a reasonable person, informed of all of the information, could perceive that you taking a client from either your employer or your former employer into your private practice, could it be perceived that either your professional or financial interest was influencing you in carrying out your professional obligation to that client? So that's something to really consider and really review. And again, I've mentioned before as well, having that introspective self-reflection that, am I the best person for this? Is there anybody else who could do this? Those might be questions that you need to ask as well. And maybe there isn't anybody else who could do it. Maybe you are the best person who could do it. But again, also thinking that if I ever needed to defend this decision to somebody else, to an employer, to a colleague, to the college, how would I defend this decision? And that I was mindful of the potential of being in a conflict of interest. And I was thoughtful about how I moved through it and how I moved to eliminate that conflict. So it can happen. Oftentimes people do put at least a grace period between, or you'll often hear of individuals offering their clients like a list of resources, and they might be one of those resources. There is a counter argument to that are you actually giving the person choice? If your name is there, would they feel that they had that choice? So it depends is the answer to the question. It's not without risk. And where you need to start first and foremost is if you're even allowed to do that based on your company policy. Or would it be potentially your employer could be referring people to you as well. So Andrea, I realize we've got 15 minutes left, and there's some other topics for me to explore as well that hopefully in the next 10 minutes, I can just go through them, and then we'll have some more time at the end for a bit more questions. Does that sound good?
Go ahead.
Perfect. So financial management and billing was, and you'll notice that I'm going to talk a little faster here, I'm sorry. So for financial management, the college doesn't have requirements and guidance on financial management specifically, that those are business decisions that you should be making with the assistance of an accountant or a lawyer or through consultation with other private practitioners. And similar to this is that the fee rates and fee schedules that our members charge to their clients, that's not a college decision. But you should consider things such as, the cost of your overhead, the cost of your time, financial means of clients. And certainly the OASW does have some resources on what members do charge clients for in their private practice. Billing practices, and again, this speaks to one of the questions that we were asked about what needs to be on an invoice or a receipt. Well, from the college perspective, what needs to be on a bill is who provided the direct service to the client, and if applicable, who provided the supervision. So both of those individuals would need to be there. And so it has to include the name, qualifications, and professional designation of both people if there is a supervisor. If there's not a supervisor, just be the one person. And the dates of service. And typically we understand from insurance companies as well that they want at least an explanation of what service was provided. Maybe that's social work services or psychotherapeutic services. And what we really want to ensure is that the invoices and receipts are clear. And so that not only for the client, but also, you know, to ensure that they're not misleading. I've had questions from members before that, you know, it's, you know, I'm seeing the daughter, but, you know, the mom's insurance doesn't cover daughter anymore. Mom's insurance only covers mom. Can I bill under mom's name? And it's like, well, the standards of practice talk about the fact that we can't knowingly sign any invoices or other documents that are knowingly false or misleading. And that could be misleading if we're saying that we provided service to one person when in fact it was their daughter, for example. Then the other big topic that we've obviously had a lot recently is on communication technology, because this is how so many people have transitioned their practice these days. And the college has an awful lot of information about this on the website as well. We've got several practice notes about this. We recently put out our top 6 considerations for selecting a virtual platform as well. So there, if we don't go through this in the depth that you need, there's certainly more resources to go and check out on the college website as well. So of course, we know that there's a lot of considerations: security, maintaining boundaries, and even exploring your own communication technology or social media policy. So security of communication is a big one, because we know that many modes of communication aren't secure. Some email, Skype, for example. And so this is one of the reasons that we put out this most recent article that we have, the top 6 considerations when considering a virtual platform. And we go through what are some of the security considerations that you need to look at, you know, end-to-end encryption, are the files stored in database that is located in Canada? If it's not, are they compliant with Ontario or Canadian privacy laws? So those are really outlined in this article that we've recently released that you can find on the college website. And what we really need to do is when we're exploring these different modes of communication with clients, when we find out, you know, what again are about their limitations, that we need to provide this with clients about the informed consent process. So again, just to rehash that, we want clients to be provided with accurate and complete information regarding the extent, nature, and limitations of services, including the online platform that they may be communicating with you with. Similarly, you know, when it says interpretation 5.4 confidentiality, that's talking about the limits of confidentiality with clients. So we understand, you know, that Zoom has had its issues in the past, right? But, you know, oftentimes members may choose to use Zoom and explain all of the different risks and security issues. And if a client understands that in an informed way, that they may choose to proceed with service. And so those are some of the security considerations that people need to review when considering communicating with clients via online platforms and online technologies. And this is just to highlight some of these issues. Sometimes it's useful just to look at a case study as well. Just for accessibility reasons, I will read it. A member has been approached by a client seeking a mix of video, email, and telephone counseling services. The client reported that she's often in crisis and as a result, sometimes needs to have sessions while she's walking outside or in public places. The members decided that they should consult with the college before agreeing to provide services to the client. There's a lot here. It seems pretty simple, but there's actually a lot here. And so these are some of the extent, nature, and limitations of service that we're talking about. That first of all, of course, we need to verify with the client that, you know, if we're using video, if we're using email, if we're using telephone counseling services, what are some of the limits to service here? What are some of the confidentiality issues? Does a process need to be established to verify the identity of the client if they're emailing you? How are you going to manage a technological problem or loss of connectivity with the client? What is the crisis plan that has been established with the client? You know, if somebody endorses suicidal ideation and then hangs up on you or closes off Zoom, what are you going to do then? And especially because the client here is talking about that they want to walk outside in public places, you know, what are the limits of confidentiality? You know, you can only guarantee confidentiality on your end at that point in time, not on the client's end if they're in public. So how are you going to navigate that conversation? Another interesting point that a member brought up to me when looking at this case study was, well, what if they're, you know, talking and they're walking through like Christie Pitts and, all of a sudden they tell me that they're suicidal and hang up on me. Do you have an understanding of what they're wearing, or what part of the park they were in, that if you needed to call help, how would you direct them to find the client, right? So that was another interesting point too, that when we're thinking about communication technology, it really requires us to sort of open up and explore these different limitations and considerations that perhaps we haven't had to concern ourselves with in the past in that traditional direct service model. Just another case study as well, it helps kind of explore some of these different questions. That a member consulted with the college because several of their clients had been texting them to book or change appointments. They also stated one client had texted them in the midst of a crisis. The member wanted to ensure that they were practicing in accordance with the standards of practice when using these forms of communication with clients. The member was also seeking guidance as to how they should document these interactions. So again, very common things that we're hearing these days from members. And so, how are we ensuring that we're using communication technologies appropriately with clients? Are we ensuring that if they're texting us, are they including clinical information in those texts? Should they be? Should they just be used for administrative purposes? We've also heard complaints from clients at the college as well, that they have been trying to communicate with their members via email or text, and the member hasn't gotten back to them in a time that they felt was satisfactory. So have you clearly responded to your clients? How often you're going to check and respond to these different types of communication? And also, are your clients aware of your documentation practice? We've also heard complaints from clients that they requested a copy of their file and then found their emails within the file and thought, well, email is an inherently informal way of communicating. Why is this part of my client file? And that wasn't explained to them at the outset that could be something that would be put into their client file. So these can be things that sometimes we need to consider, explaining them to our clients, again, about the limitations and expectations of service. So this is just a quick checklist to go through some of these things that I've just highlighted here, and they are all available, of course, in one of our practice guidelines as well. And just to kind of highlight some of the more salient points. So we need to make sure that we've explained to clients the limits of confidentiality when using communication technologies. And also you've clearly articulated your policies and practices about seeking client information online. This is an interesting one that we've heard about, our members Googling clients and then clients finding out about it and not being too happy about it. So that's something to consider as well, that if you are going to do that, then you should be transparent probably with clients, or let them know why you would be doing that, how that information would be used, or maybe just not do it. You've been very clear about what, if any, information will be communicated outside of clinical sessions. That can sometimes be a useful clinical tool for members, and sometimes it's just a no-go boundary issue that we're not communicating outside of our clinical sessions. If you are communicating outside of clinical sessions, and that should be care planned, it should be documented, it should be transparent as to what the nature and purpose of that is. You've told clients how often you check your messages, and you've made it explicit about whether or not you'll respond to them. Some members will receive messages in between sessions, but they won't respond to them. So another interesting point. And just general information, what will be documented in the client record, whether or not you're going to accept friends, probably a good idea not to do that. Developed a crisis plan, and of course, obtained legal advice as needed. I appreciate that was very tricky, but it is all in this practice note that's just at the bottom of your screen here. Communication technology practices for a digital world. That is a checklist that is available on the website. We also have something that's on cross-jurisdictional practice. We have talked about that already. And I'm just very conscious of the term because we've got 5 minutes left. But there were several other things that people wanted to talk about. And I can very quickly say that the college doesn't offer liability insurance, but we do recommend it. Many of our members purchase their liability insurance through the OCSWSSW. Effective advertising strategies. I mean, that's a really good topic to discuss in your networks about what are the most effective ways to advertise your services. Online platforms, I have mentioned that one resource that we have, the top 6 considerations for virtual platforms. Taxes, you need to consult obviously with an accountant or with your lawyer about that. Registering and incorporating your business. If you want to register your business, again, or incorporate your business, these are personal choices that should be made. They're not required by the college. They should be made under the advice of an accountant or a lawyer. Registering your business is something you can do online through Ontario Businesses. Incorporating is something that you can do through the college. They both have their benefits and deficits, but I certainly encourage you to speak to a lawyer or an accountant about them. We had a question about the college's ability to speak to universities about social work program curriculum. The college has very open dialogue with colleges and universities, but we aren't able to direct what their curriculum is going to be. But certainly we do, have regular conversations with them and have a very open dialogue and maintain good relationships. And just therapeutic modality certifications was the last question that I was able to get in there real quick. And the college doesn't recommend any specific modality. We don't say that anyone is better than another, but certainly whenever you're choosing to do ongoing training, do your homework, make sure it's offered through a credible institution, talk to your colleagues, shop around, make sure that you're not signing up for somebody who doesn't know what they're talking about essentially, because they're out there, unfortunately. And so you want to make sure that you're getting it through a credible, reputable organization that hopefully has, some individuals that, have taken those courses as well. So that was very quick, but we had so many good questions and so many good topics that I was asked to talk about. So I appreciate that there's not a lot of time left for questions. I will stay here for as long as you need to answer some questions, but of course, as I said, please do email me as well. My email is right there, and you're welcome to, I'm not in the office, as you can see, so please do email me with your questions if we're not able to get to them.
I was just going to say that we have maybe another 5 minutes, but there's 42 new messages. Ooh. So we're probably going to have to revert to using your email for people who have specific questions.
Yes,
but just to remind everyone that the session was recorded.
Yes.
And it will be sent out to each registrant. So a lot of the questions that are in the chat, you did answer, you did speak to them.
Oh, thank you.
Some people reframe them in another way, but the answer is there. Or they can email you as you rightly said. Yeah.
Absolutely. Yeah.
There's a question here asking if there's a software recommendation for documentation. Yeah. I imagine you guys aren't endorsing anyone.
We're not allowed to.
I didn't think so.
Yeah, for a variety of reasons. I think OCSWSSW has taken their advertising someone, so that's certainly somewhere to look. But like I said, we've created this document to highlight the different considerations that members should explore when choosing a database or an online platform.
Yes. There's a question that asks about contingency plan for documentation. If you have a concrete example.
That is a very good question. A contingency plan for documentation. Do you know what? Could that, whoever wrote that, please email me, because I need a little bit more context to be able to answer that question. That's a new one for me. So I'm sorry I can't give you an answer right now, but please do email me.
Yeah, I think certainly it's Ellen Dickinson. I think the context was when you were discussing documentation and keeping it for 7 years or 7 years after the young person has turned 18, and the fact that you would need to keep it in a safe place and have a contingency plan if you are not alive or if you're not practicing any longer.
Thank you for the clarification. So just quickly, I mean, some people do put it in their wills as to, and they have a conversation with a professional, and they put the agreement in writing between the two professionals as to, in the event of my death, you will take over, here are my passwords to access this, that, and the next thing. And so then that is also put into the will. And then there's also a plan that the professional who's taking over from you with in the event of your death or for other reason that you're not able to access records anymore, about how they would notify your clients as well about where to go in the event that you were no longer able to give them the records if they requested it.
Someone was asking, can you share how to come up with who would benefit from a reduced fee?
Who would benefit from a reduced fee?
Yeah, can you share how to come up with who would benefit from reduced fee? Rachel, you could speak. Can I unmute you? Or can you unmute yourself? I'm trying to find her. If you were here, Rachel.
Okay, they can unmute themselves now. I locked it down for a bit, but.
Okay.
Yeah, I was just wondering about, sometimes I have clients who would like a reduced rate. Usually I limit that to a certain number of clients. But I know that other therapists have different ways of deciding who gets the reduced rate. Like they'll have a panel of people, professionals, and they talk amongst themselves, and they have certain parameters around who, like how they go about deciding who receives the reduced fee. So I'm just wondering if you have any recommendations around that.
Yeah, that's going to be a very kind of personal practice decision. And the college isn't going to determine how you do that. You certainly can do that. Certainly we know, for example, there's organizations like Hard Feelings that offer all low-cost counseling as well. So that can be a potential referral source if you need to. But, I think one of the more common ways that I have heard of is to offer a sliding scale. And so that's to kind of do a critical analysis of, where the client is at, where you're at, and what's the lowest point that you can go to in order to meet their needs while still meeting your own business needs as well. But I'm sorry, I don't have a recommendation beyond kind of exploring it through a sliding scale situation, or, as you said, conversing with your colleagues and figuring out if there's a network or a way to communicate with each other about who's taking on kind of those low cost referrals for that time.
I'll ask you one more, Christina, as people are leaving the line very quickly, and we are at 8 o'clock or past 8 o'clock. The last one I'll ask you is, to be clear, the question says, does that mean we cannot have a Google business listing where clients can leave reviews?
Right. So I don't know if you have a choice to be able to do that or not. And so that can be a tricky one. And so what we do in that case is we ask members if they have IT savviness themselves, if you have a web developer or IT person who helps you with that, to try to figure out how to disable that and how to turn it off. I mean, if it is a choice, then by all means, I would suggest perhaps not to choose that. But I appreciate and have heard that at times this is something that Google just does. So what the standards of practice talk about in this situation is to advocate and try to create workplace consideration or workplace, I've lost my words there for a second, but workplace environment that's inconsistent with the standards of practice. And so trying to marshal your resources to figure out how to disable or turn that off, or even bury that in your click feed, that could be a way to look at that. But I have heard from members that that's just kind of an inherent part of being online. And I don't know if that's true or not, but certainly we would advise members to try their best to limit that if possible.
I think that should be it for us. We are now past 8 p.m. And of course, there are many questions remaining in the chat. But as Christina rightly said, her email is here. There are lots of thank yous also coming.
Thank you.
But we're all very grateful. Thank you, Christina, for your patience and your preparation and your thoroughness in preparing your responses. Thank you so much.
My pleasure. I tried to touch on everything you asked me to.
You did. You did a great job. Thank you. Thank you. I don't know how you could have gotten any more. Wow. And yet they're still coming, right? They're still coming.
Well, thank you very much. I really appreciated the opportunity.
Thank you.